So we're up to about 23 participants at this point, and we're going to get started. We have a lot of material to cover. First, welcome to our webinar on understanding PFAS in emerging regulation and issues in business transactions. We're going to cover a lot. We're going to start with Sara Blair is going to talk about what PFAS is and the federal regulatory arena these days, followed by my colleague Chris Ward, who's going to talk about state regulation and business transactions. A couple of things, housekeeping. If you have a question, if you could put it into the Q&A, ask them at any point during the presentation, and we'll try to answer them. We'll also have some time at the end to answer questions. And if you are getting continuing legal education credit, there will be 4 polls that will pop up during the course of the webinar that you should respond to, and that will get you your credit. I wanted to set a little bit of context because what you're going to hear about today are lots of regulations and standards that are measured in parts per trillion. If you're an old guy like me, and I started in environmental law, we talked about parts per million. And that, to give you a sense, 1 part per million would be the equivalent of 1 inch in 16 miles. 1 part per trillion would be 6 inches in 93 million miles. If we think about it in terms of liquid measure, 1 part per billion would be 1 drop of PFAS in 500 barrels of water. Compare that to 1 part per trillion, which is 1 drop in 500,000 barrels of water. So we're talking about extremely small amounts that are now being regulated at one level or another. So with that context, I'm going to turn it over to Sara Blair, and she can fill us all in on the U.S. federal regulations and legislation, and then she'll go to Chris Ward. So with that, welcome and thanks for joining us.
Thanks, Chris. I'm going to start by giving you a brief introduction to PFAS. What are they, where can they be found, and why are we so concerned? PFAS is an acronym for per and polyfluoroalkyl substances. They are a diverse group of human-made persistent synthetic compounds and used in a wide range of consumer and industrial products. There are approximately 650 different kinds of PFAS currently in commerce under the Toxic Substances Control Act, or TSCA. And according to the U.S. government, at least 4,000 PFAS are or have been on the market since 1940. 2 exemplary PFAS, which you might hear mentioned throughout this presentation, are PFOA and PFOS. These are 2 of the most widely used and studied chemicals in the PFAS group. PFOA and PFOS have been replaced in the U.S. with other PFAS in recent years. For example, PFAS, a PFAS called Gen X, has been used as a replacement for PFOA. But in many cases, however, the replacements have been other PFAS materials that carry with them similar environmental and health risks. PFAS own their unique properties to a carbon-fluorine bond, which is one of the shortest and strongest known bonds. And this property also makes these chemicals, or the parts of them composed of this CF bond, highly resistant to breakdown in the environment, earning them the nickname, which you might have heard, forever chemicals. As I'll describe further, these compounds offer PFAS characteristics such as heat, stain, and water resistance that are desired by industry and consumers alike. Chemical companies have manufactured PFAS for decades for use as manufacturing aids and in consumer products. And one characteristic shared by many substances in the PFAS group is that they can bioaccumulate in humans and animals in the environment over time, meaning exposures to even small doses of PFAS over long periods can accumulate in our systems and in the environment. PFAS have been in use since the 1940s, and they're still in use today in a variety of consumer products and industrial applications, including firefighting foams, which you might hear referred to as AFFF, paint, coatings for clothes and furniture, carpeting, and cleaning products. Certain PFAS are authorized by the Food and Drug Administration for use in cookware, food packaging, and even food processing equipment. Certain PFAS chemicals are no longer manufactured in the US as a result of their persistence in the environment, but many of these products are still produced internationally and can be imported into the US in consumer goods such as carpet, leather and apparel, textiles, paper and packaging, coatings, rubber, and plastics. PFAS can be present in our water, soil, air, and food, as well as in other materials found in our home and workplaces. The most significant source of known PFAS contamination are facilities that manufacture these chemicals and military bases that conduct extensive firefighting training activities. In certain locations, a lack of adequate waste storage and disposal practices at chemical manufacturing facilities has resulted in further contamination of groundwater and surface water. I'm going to expand this graphic here to your right, and it shows just how prevalent PFAS are in our environment. As you can see, some examples of where PFAS can be found include in public drinking water systems and private drinking water wells, at landfills, disposal sites, hazardous waste sites, in the AFFs used to extinguish flammable liquid-based fires. Such foams are used in training and emergency response events at various locations, including airports and shipyards, military bases, firefighting facilities, chemical plants, and refineries. At manufacturing or chemical production facilities, such as chrome plating, electronics, and certain textile and paper manufacturers. In our food, for example, fish caught from water contaminated with PFAS, or dairy products from livestock exposed to PFAS. In our food packaging, such as grease-resistant paper, fast food containers, and microwave popcorn bags. In our homes, such as on carpet, upholstery, and clothing, in personal care products, shampoo, dental floss, cosmetic, and in fertilizer from wastewater treatment plants that it's oftentimes used in agricultural lands, which can further affect ground and surface water and animals that graze on land. So as you can see from not only this graphic, but also from my lengthy description, PFAS can essentially be everywhere. And you're probably already picking up on why PFAS have become such a topic of concern. It's the sheer breadth of use over the last 80 plus years, coupled with the ability of PFAS to accumulate in our bodies and in the environment over time, means that PFAS can essentially be found everywhere, in surface water, groundwater, soil, air, and even within us. Due to their widespread production and use, as well as their ability to move and persist in the environment without breaking down. Surveys conducted by the CDC show that most people in the US have been exposed to PFAS. And essentially, we all most likely have some amount of it in our systems right now. Most known exposures are relatively low, but some can be high, and particularly when people are exposed to concentrated sources over long periods of time. PFAS exhibit a wide range of exposure pathways, and current research has shown that people can be exposed to PFAS by working in occupations such as firefighting or chemical manufacturing, drinking water contaminated with PFAS, eating certain foods that may contain it, including fish, swallowing contaminated soil or dust, breathing air containing PFAS, or using products with PFAS or that are packaged in materials containing PFAS. Some PFAS have the potential to cause serious health problems such as cancer and reproductive harm. Studies have shown that exposure to certain levels of PFAS may lead to reproductive effects such as decreased fertility, developmental effects or delays in children, including low birth weight, increased risks of some cancers, including prostate, kidney, or testicular cancer, reduced ability of the body's immune system to fight infections, interference with body's hormones, and increased cholesterol levels and/or risk of obesity. PFAS-containing products are regularly disposed of in landfills or via incineration, but PFAS's inability to break down in the environment means the removal of PFAS from contaminated areas just can create additional PFAS-contaminated waste. Unsafe storage and proper disposal and inadequate containment has resulted in contamination of soil, water, and air in some of these disposal locations. One point to note is the use of PFAS is widespread, but the US EPA has identified only 6 to 8 facilities that produce PFAS feedstock, and most significant PFAS discharges are found in only a handful of industries, including PFAS production and processing, metal finishing, airport, pulp and paper production, landfills, and textile and carpet manufacturing. Now that I've given you a pretty good idea of why PFAS is considered such a problem, we can discuss how the US government has responded or plans to respond to the PFAS issue, including a few key recent actions taken by the US EPA. I'd like to emphasize just how new this issue is. Until recently, PFAS was a relatively unheard of term. Historically, in air quotes, the US government's response to PFAS has been primarily limited to non-enforcement mechanisms, such as pursuant to health advisories promulgated in 2019 and 2020, which recommended certain concentration levels of PFAS in drinking water or required manufacturers to notify the EPA of the manufacture of PFAS chemicals or products containing PFAS chemicals. These types of federal health advisories are not legally binding, although government states could use them to set their own PFAS drinking water standards, as Chris will talk about later in the program. In April of 2021, the US EPA established the EPA Council on PFAS, and in October 2021, the EPA Council released the PFAS Strategic Roadmap for the years 2021 to 2024. The roadmap sets forth US EPA's strategy for tackling the PFAS problem. The roadmap refers to three primary objectives. The first is research, which includes better understanding PFAS exposures and toxicities and the dangers to human health and the environment. The US EPA is looking to establish an evidence base on which individual PFAS and certain defined categories of PFAS to help establish toxicity values and methods for each category. Increasing scientific understanding of the PFAS universe, including sources of contamination, exposure pathways, and human health and ecological effects, is also a goal. And they'd also like to expand research on current and emerging treatments, remediation, destruction, and control. Much is still unknown about the exposure to PFAS and in what concentrations and over how long it will affect us and the environment. So it's important to note that while much of this research is still ongoing, state and federal regulators are eager to race towards establishing limits and standards for PFAS in water and soil and air that oftentimes may not yet be as supported by these continuing scientific and research studies. The second objective is to restrict, which includes proactively preventing PFAS from entering the air, land, and water. And the EPA plans to harmonize actions under all the statutory authorities to control and prevent PFAS contamination and minimize exposure to PFAS. And they intend to place responsibility for limiting exposures on manufacturers, processors, distributors, importers, and treatment facilities. And lastly, the third goal is to remediate, and meaning the US EPA intends to accelerate cleanup of existing PFAS contamination, including, again, by harmonizing actions under the available statutory authorities, and also maximizing responsible party performance and funding for investigations and cleanup of PFAS contamination. They'd also like to ensure impacted communities receive resources and assistance, and to accelerate deployment and treatment and remediation and disposal technologies. Under the framework of these three primary goals, research, restrict, and remediate, the PFAS Strategic Roadmap sets forth a multidisciplinary approach to achieving these goals, engaging each of the Offices of Chemical Safety and Pollution Prevention, water, land and emergency management, air and radiation, and research and development. I'm going to talk through some of the major milestones that each of these offices has achieved since 2021 and some upcoming PFAS-related actions that are currently in progress. With respect to the Office of Chemical Safety, Pollution, and Prevention, they've achieved or are working on achieving a number of their milestones under the strategic roadmap. First of which, in 2021, October of 2021, US EPA issued a national PFAS testing strategy, which will require PFAS manufacturers to provide toxicity data and information on categories of PFAS chemicals to inform future regulatory efforts. The EPA will select the PFAS to be tested based on an approach that breaks the large number of PFAS into 9 primary categories based on similar features and considers which existing data is available for each category. And the goal is to gather toxicity data and determine what gaps that there are existing. The EPA expects to use its TSCA Section 4 order authority to require PFAS manufacturers to conduct and fund these studies. And the first test order was issued in June of 2022, and the agency plans to issue additional orders in the coming months. Another milestone to highlight is in January of 2023, the EPA proposed a Toxic Substances Control Act, again, TSCA, Significant New Uses Rule, or SNUR, for approximately 300 PFAS that are listed on the TSCA inventory but deemed inactive, meaning they haven't been actively manufactured, including imported or processed in the US since June of 2006. Persons subject to the SNUR would be required to provide the EPA a significant new use notice at least 90 days before manufacturing, importing, or processing the chemical substance for a significant new use. This can be a substantial undertaking and may include submittal of additional studies and data. After US EPA releases a significant new use notice, it'll make a determination and take such action as required by any such determination before the manufacture or processing of the significant new use can commence. The review is intended to assess whether whether the use may present unreasonable risks to health or the environment and determine whether EPA can prevent future environmental releases of the PFAS subject to the SNUR. The proposed SNUR's comment period closed in March 27th of 2023, and the EPA predicts a final SNUR by December 2023. An additional item to note is in May of 2023, the EPA issued proposed updates to the new chemical procedural regulations under TSCA. The proposal includes amendments that would make PFAS categorically ineligible for low volume exemptions and low release and exposure exemptions under TSCA, meaning that all new PFAS chemicals would be required to undergo full pre-manufacture notice under TSCA. As of 5 days ago, the public comment period on this new issue has been extended to August 8th, 2023. Lastly, in December 2022, the EPA proposed another rule that would, among other things, expand the scope of the toxic release inventory, or TRI, PFAS reporting. If enacted, this rule would apply to PFAS subject to the Emergency Planning and Community Right to Know Act, PECRA, and Pollution Prevention Act reporting, and would add them to the list of lower thresholds for chemicals of special concern, and would eliminate the de minimis exemption for reporting TRI listed PFAS. On June 23rd of this year, the US EPA published a final rule that would add 9 new PFAS to the TRI list of reporting under PECRA. Facilities subject to TRI reporting requirements that manufacture, process, or otherwise use the 9 new TRI listed PFAS will be required to report beginning in the reporting year 2023. As with the existing 180 TRI listed PFAS, the reportable thresholds for the 9 new PFAS will be 100 pounds per year. And as of now, until the EPA takes action on the aforementioned December 22 proposed rules, all 189 TRI listed PFAS can still qualify for certain burden reducing exemptions and tools, such as the de minimis reporting exemption. Now we'll move on to the Office of Water, which has met or is in the process of meeting a number of its milestones under the strategic roadmap. Firstly, in December of 2021, the Office of Water promulgated a final rule regarding the nationwide monitoring for PFAS in drinking water. Under the existing unregulated contaminant monitoring rule, which is used to monitor for priority unregulated contaminants in drinking water every 5 years, public water systems serving more than 3,300 people are to collect samples during a 12-month period from January 2023 to December 2025 to test for 29 PFAS found in drinking water systems. Secondly is the National Primary Drinking Water Regulation for PFOA and PFOS. On March 14, 2023, the EPA announced the proposed National Primary Drinking Water Regulation for 6 PFAS chemicals. The EPA is proposing this regulation to establish legally enforceable levels called maximum contaminant levels for the 6 PFAS in drinking water, including PFOA and PFOS as individual contaminants and certain other contaminants, including Gen X chemicals, as a PFAS mixture. EPA is also proposing health-based, non-enforceable maximum contaminant level goals for these 6 PFAS. As you can see on this slide, the EPA is proposing an MCL of 4 parts per trillion for PFOA and PFOS, and a maximum contaminant level goal of 0 parts per trillion for these chemicals. This is consistent with EPA's controversial position that these are likely human carcinogens and there's no safe level exposure for these two chemicals. The draft rule also targets 4 other PFAS, including HFPO, PFNA, PFHXS, and PFBS. This part of the rule would limit any mixture containing any one of the 4 additional PFAS through application of a hazard index, which adds the health-based water concentrations, HBWCs, of these 4 PFAS when present in the sample to determine if the water is safe to drink based on combined toxicity. The draft rule proposes settling the HBWCs of these 4 constituents and 9 parts per trillion, 10 parts per trillion, 2,000 parts per trillion, and 10 with respect to Gen X chemicals. This is the first time a hazardous index has been used as an MCL. If you can recall from Chris's visualization of just how minute a part per trillion is, we're talking about essentially no PFAS in drinking water, which will have a huge impact on public water systems. If finalized, this rule would require public water systems to monitor for the 6 PFAS and notify the public if PFAS are detected at levels that exceed these proposed regulatory standards. If the PFAS are detected at these levels, municipalities and other regulated entities would be required to take action to reduce the levels if they exceed these standards. Public water systems would be regulated under the proposed rule, including community water systems and also non-transient, non-community systems, such as systems that supply water to school, daycares, and factories. Transient non-community public water systems would not be subject to the proposed rules, such as restaurants, campgrounds, or highway rest areas. There are no actions required until this proposed rule is finalized, but EPA anticipates finalizing the regulation by the end of 2023. With respect to the Office of Land and Emergency Management, the following milestones have been met or in progress. Firstly, in September of 2022, the office issued a proposed rule to designate certain PFAS, including PFOA and PFOS, as hazardous substances under the CERCLA, Comprehensive Environmental Response, Compensation and Liability Act, otherwise known as CERCLA or the Superfund Law. Generally speaking, CERCLA provides the federal government with statutory authority to investigate, monitor, and respond to hazardous substances that have been released or are under threat of release in the environment. CERCLA also provides enforcement mechanisms for the government and private entities to hold parties responsible for cleanup costs if they're found to be liable for a release of substances that are either specifically designated as hazardous substances under CERCLA or to determine to present an imminent and substantial danger to public health or welfare. While it's possible to engage CERCLA process to address PFAS contamination prior to this proposed formal designation by establishing that it poses an imminent and substantial danger, it will become much easier to establish liability for release of PFAS as a hazardous substance moving forward. The final designation will have a number of immediate implications under CERCLA's liability framework. For example, any person or entity that releases these chemicals above the permitted levels would face strict notification requirements, and the EPA would gain additional authority to order response and remediation actions of sites around the country where these chemicals are located, and can hold entities that contribute to the release liable for cleanup costs. Private parties could also easily bring cost recovery action for PFOS and PFOA cleanups. The final designation of PFOS and PFOA as hazardous substances may also have various wide-reaching effects beyond those statutorily imposed by CERCLA. The final designation could significantly increase the number and duration of remediation activities at even closed Superfund sites, active Superfund sites, or new Superfund sites. For example, the designation could lead to the reopening of previously closed sites due to the presence of these chemicals. And for existing Superfund sites that may be near closure, these designations could push back the timeline of remediation projects and add significant costs and testing protocols and require treatment technology and prolonged site monitoring. And of course, adding PFOA and PFOS to this list of CERCLA hazardous substances could lead to the designation of an entirely new Superfund site based on the presence of these chemicals. This could also have a significant impact on businesses and entities responsible for release. You know, any PRPs could include manufacturers, PRPs meaning potentially responsible parties, could include manufacturers and importers, PFOS and PFOA, or businesses that use these chemicals, or waste management, or even wastewater facilities that treat them. All PRPs could face a heightened risk of government enforcement and private litigation, and especially since, those parties could be held jointly and severally liable for 100% of the cleanup costs. This is a very significant concern. So, similarly, owners or operators of agricultural businesses may face risks if their property was treated with pesticides containing PFAS, or site owners might need to reassess the values of their property and estimate the legal and financial responsibilities associated with them. Second milestone to note is with respect to RCRA, or the Resource Conservation and Recovery Act. In October of 2021, the Office of Land and Emergency Management issued an updated guidance on destroying and disposing of certain PFAS and PFAS-containing materials under RCRA. They added 4 new PFAS chemicals as hazardous constituents, including PFOA, PFOS, PFBS, and GenX. The guidance also clarified regulations stating that RCRA Corrective Action Program has the authority to require investigation and cleanup for wastes that meet the statutory definition of hazardous waste under section 1004, parentheses 5. This modification would clarify that emerging contaminants such as PFAS can be cleaned up through the RCRA corrective action process. Some additional actions are being taken by the remaining offices of air and radiation and research and development, including with respect to the air and radiation, building a foundation to address PFAS air emissions. This is an effort that's still ongoing, and the focus of recent years has mostly been with respect to land and water exposure pathways. With the Office of Research and Development, the office is tasked with developing and validating methods to detect and measure PFAS in the environment, advancing understanding of effects on human health and the environment, and developing the technologies for reducing and mitigating the effects of PFAS in the environment. Much is still unknown about these effects, and that's why why this portion of the EPA's work is so arguably essential, as the sooner we can obtain reliable data, the sooner we will hopefully inform the regulatory framework regarding exposure limits. The EPA is also directing agency-wide efforts related to community engagement, including educating the public about risks, issuing annual progress reports with respect to the strategic roadmap, the first of which was issued in November of 2022, and establishing enforcement tools to identify and address releases. Those are just some of the recent and significant highlights with respect to PFAS related U.S. regulations. As you'll note, this is an ever-changing framework, and we can look forward to additional changes in the next year or so, including changes to the NPDES permitting requirements, finalized drinking water standards, effluent limitation guidelines, and national ambient air quality criteria. Ambient water quality criteria. Lastly, before I turn it over to Chris, I'll run through one recently proposed piece of federal legislation related to PFAS. In June of 2023, U.S. Senators Tom Carper and Shelley Moore Capito released a final draft bipartisan bill related to improving the mitigation and remediation of PFAS contamination. This draft legislation includes provisions that, among other things, set a September 30th, 2024 deadline for the EPA to complete the ongoing rulemaking process to set the drinking water standards, support the ability of states to inventory industrial users of PFAS within their borders, authorize grant programs for the development of treatment technologies, and create a prize competition to encourage innovation in the development of said technologies. The bill also aims to help the EPA fill gaps with respect to PFAS and build support to address growing public concerns. It includes provision that one I think is pretty essential, which is provide a consistent and practical definition of PFAS compounds for use by federal agencies, state government, and other entities. It will also help, is intended to help bolster the understanding of beneficial uses of PFAS in commerce, and directs the EPA to create a clearinghouse of state and private sector best practices to support informed decision-making on chemicals. And EPA will also be directed to work with external standard-setting organizations to supplement their work on PFAS standards, including for detection, reduction, remediation. Lastly, with respect to addressing community challenges related to PFAS, the draft legislation includes provisions that amend the Safe Drinking Water Act state response to contaminants, as amended by the Infrastructure Investment and Jobs Act, to allow states to assist individual well owners with PFAS contamination. Stakeholder comments were accepted on this legislation until July 3rd of 2023. So we will see how that progresses. And with that, I will turn over to Chris Ward for a discussion of the current state regulatory framework and implications of PFAS on business transactions.
Thank you, Sarah. Again, my name is Chris Ward, and I'll be guiding you through the remaining two parts of our presentation today. First up, now that Sarah has discussed the current federal regulatory status of PFAS regulation, I'll now walk through the states where in many cases there's been much more action on the ground. The main four areas where we're seeing PFAS legislation and regulation at the state level are drinking water, groundwater and soil remediations, hazardous waste regulations to a smaller extent, and then a lot of action in the area of commercial and consumer products. As with the federal response, obviously a lot of attention has been paid to drinking water. State regulations on PFAS and drinking water have taken on a lot of different forms, making them difficult to track and group on the national landscape. But we'll do our best here to give you an overall take as to what states are doing what. The main pathways states have taken include notification levels, guidance levels, and maximum contaminant levels, or MCLs, as Sarah mentioned before. Now, sometimes you will also see terms like action level or response level, but let's narrow those for the time being. Notification levels. In this situation, a corporate representative may have a duty to inform an appropriate state official that a drinking water concentration in a water source owned or operated by the company, public well, supply tank, such as, for example, that those are above the state limit. There may also be a duty to inform customers, if applicable. A guidance level is where the state has established a recommended concentration limit for one or more PFAS substance, but no notification or other action is required if the concentrations exceed the recommended limits. Essentially, this is a health advisory. And finally, MCLs. This is the limit on the max amount of PFAS compound that can be present in drinking water. Treatment facilities that supply drinking water must ensure that these limits are met by treating and filtering the drinking water, and also limiting the discharge of PFAS compounds, typically through some kind of permitting process at the state level. As opposed to our advisory levels and health advisories, this is an enforceable limit. Sarah mentioned these earlier, but the most common state drinking water regulations are targeting PFOA and PFOS, but many states have also included a broader range of the PFAS compounds listed on this slide. Now, until the federal government enacts MCLs for PFOA and PFOS, the regulatory landscape for all PFAS compounds in drinking water is going to consist of these wide varying array of state promulgated standards and regulations. Let's start with the first category of state drinking water regulations, those with enforceable MCLs. We've got 10 states that have set MCLs for PFAS in drinking water. Many of these are in New England, and those are following a similar path in terms of their MCLs, as you can see, looking at Maine, Massachusetts, Vermont, and Rhode Island, following a similar path with their state regulations. But some of the most stringent limits can come from outside of New England, as we see with Michigan's 6 parts per trillion for PFOA. And now some of the more recent states that have joined this would be Pennsylvania and Wisconsin, who passed their MCLs recently. You can also see from from this list here that grouping and combining of PFAS substances under one limit is a common approach. For instance, Massachusetts will call those the PFAS 6. Some have a wide range from, for instance, in Michigan, 6 parts per trillion for PFOA up to 400,000 of another PFAS compound. But you can see a common range developing here in the States from about 6 parts per trillion to 70 parts per trillion in the most stringent situations. That 70 parts per trillion, you can see with Wisconsin, that would be likely pulled from the EPA's health advisory that has been in effect for a couple of years. I'll come back to these MCLs when we discuss again Sarah's information on the federal response to drinking water MCLs. Next, we have a handful of states who have set advisory guidance levels for PFAS compounds. Essentially, these are health advisories. As Sarah discussed earlier, the Gen X chemicals, the PFAS replacement chemicals, that's the trade name for HFPODA, also called C3-dimer acid. And it's a chemical, it is an acronym for a chemical compound used in the manufacture of these fluoropolymers. But because it's relatively new as a replacement to move away from PFAS, it has limited peer review studies. But as you can see, some states are already adding it to the list at guidance and advisory levels. Looking at this chart to just give you an illustration of the range here, we've got 2 parts per trillion in one compound at a guidance level in Illinois. Think back to Chris's discussion of what actually is a part per trillion, and you realize that Illinois' guidance level at 2 parts per trillion for one PFAS compound is essentially unrecognizable. But we're moving all the way up to 667 parts per trillion, for instance, in Nevada's guidance levels. So a wide range. What we see here with the guidance levels is just some states trying to do something with regard to PFAS. Next, we've got a third category of notification levels. You'll also see these often called perhaps an action level or response level. Response levels usually involve taking a water system out of service when there's a determination that PFAS contamination levels exceed the set level. But beyond that, the action or notification levels come into play when the water system does not take the source out of service, and there's going to be some kind of notification to a government body and or customers. California is on this list. They do not have MCLs yet, but their notification levels are very stringent and for some PFAS compounds under 1 part per trillion. And this is the list where you'll also find Ohio, which some on this presentation might be interested in. Ohio is at the 70 parts per trillion health advisory level right now. And of course, there's a fourth category, a number of states that do not have any current PFAS regulations. There's about 24 states here. So the trends that we're seeing, which will be more visually evident here on my next slide, this is an illustration of where we're at nationwide on drinking water. The Mid-Atlantic area, we've got 2 states with MCLs, New York and New Jersey, 2 states with guidance, Delaware and Maryland. Virginia does have a working group moving closer to regulations. New England has 5 states with MCLs, 1 with a notification standard. The Midwest, we have Michigan with some stringent regulations, Wisconsin with an MCL now, Minnesota and Ohio in more of a guidance and notification level. In the Southwest, Colorado, New Mexico, and Nevada have guidance and notification. In the West, California, Oregon, Washington, Alaska are in the game. And we're seeing the most areas of no regulations in the South, Midwest, or the Central Plains. As Sarah mentioned previously, EPA issued in March its proposed PFAS National Primary Drinking Water Regulation, a step within the PFAS strategic roadmap that would set drinking water MCLs for 2 of the 6 PFAS substances at 4 parts per trillion. And I won't go through it again. The other 4 PFAS that could be regulated under this, Sarah described for you basically that hazard index calculation and equation you need to go through for the others. But what's important here are two things. Even if the proposed national drinking water regulation is passed, we're still going to have interim health advisories for PFAS, PFPA, and a final for PFBS and Gen X. And the EPA will have to decide whether to update or remove them after final rule. But of the 10 states with current MCLs that I showed you on the previous slide, please note that none of those would meet this proposed 4 parts per trillion. But until passed, those acting in these states will need to follow the applicable state requirements. And even once passed this national drinking water standard, as Sarah explained, it will have a couple-year on-roading for states to get their MCLs or no less strict compliance into play. In the absence of, we're going to move on to hazardous substance regulation here. In the absence of any formal federal regulation under CERCLA or RCRA yet, a handful of states have proceeded with some regulations under their own state hazardous waste laws. Most of these have come in terms of designations or identifications of PFAS compounds as a definitional hazardous substance. Just by way of example, back in 2017, New York was the first state in the nation to regulate PFOA as a hazardous substance, which then requires proper storage of the substances and limit releases to the environment under the state Superfund program. Another example, Delaware moved forward by updating its Department of Natural Resources and Environmental Policy for the investigation of PFAS at sites under its Hazardous Substances Cleanup Act, which includes brownfields, voluntary cleanup properties, and enforcement. Several states have promulgated standards or screening levels for soil concentrations, protective of groundwater. Please note that CERCLA regulation, should it come at the national level, would affect any of these current state regulations or cleanup standards that you can see in this slide. Also note that when it comes to air emissions at the state level, again, like the federal level, air is kind of coming later in line after drinking water and land and groundwater. But about 5 states do have some air emission regulations in progress: Michigan, New Hampshire, New York, Texas, and California. Sarah discussed with you earlier what PFAS is and where we find it in most products. But let's take a step further and see which states have moved to ban or regulate the manufacture and use of certain products typically made with PFAS. Besides AFFF, the 2 product streams most hit with regulations across the states, or bans or proposed bans, are food packaging and children's products. 18 states currently ban PFAS in food packaging or are proposing to ban them, and 12 states either ban or propose to ban PFAS as it would be contained in any children's products, which is, of course, defined differently depending on the state. While most children's products and food packaging might be the most obvious and most common state consumer and commercial regulations, depending on the state, there could be other products which are regulated as to whether PFAS is banned as an ingredient within those products. Depending on a given target company you may have in a business transaction, you'll need to pay close attention to what state the company is located or where it operates and does business, and whether any of these products use or are manufactured and PFAS is implicated in that sense. Looking at the slide here, some of those would include cosmetics in 6 states, carpets and rugs is gaining steam, and with 10 states regulating PFAS in those products, cookware, recycling, textiles, fabric treatments and apparel, upholstered furniture, pesticides, and ski wax, composting, oil and gas products, mosquito management, cannabis packaging, feminine hygiene products, PPE, and polishes. Note also that there are regulations with regard to fish and deer consumption in about 14 states, which is becoming very common. But obviously, most states, the most regulation of a certain product is in the arena of AFFF, the firefighting foam. 31 states have either a notification, a use, or a discharge or disposal regulation. Just by way of example, a state that has a discharge or a use rate restriction, these regulations usually limit or prohibit the use of AFFF in training or testing exercises and may only allow the use of AFFF in active firefighting situations. Some states have enacted state-run programs to purchase or buy back and dispose of AFFF, usually purchasing supplies from government agencies. There are also some states with notification or reporting requirements. When the continued use of AFFF is allowed, some states require businesses report specific details regarding their discharge. And lastly, there are some states that limit the use of AFFF with regard to personal protective equipment for firefighters. Note that Ohio currently has no legal limits or regulations for PFAS in consumer products or commercial production. We're going to move away from discussions of regulation to a very brief and oversimplified review of the state of PFAS litigation, which has exploded in the last few years. Since 2005, over 6,400 PFAS-related lawsuits, many against DuPont and 3M, two of the major PFAS manufacturers. Since 2000, the initial wave was directed mostly towards PFAS manufacturers and water utilities. Traditional claims, such as private parties seeking injunctive relief and remediation and damages to alleged land and water contamination, are giving way more to a new wave of claims we're seeing across the country in litigation, more state-level claims like negligence, trespass, nuisance, products liability, and some actions under different federal and state statutes. So the defendants in these type of cases, it's ballooned to a dizzying array of new, different companies, paper companies, refineries, cosmetic businesses, package producers, retailers, fast food chains. We're also seeing an increase in enforcement actions, and we expect those to increase in the coming years as it becomes further regulated, especially since those cases often don't require the same showing of causation as private injury litigation. In particular, rather than proving general and specific causation of specific occurrences of disease, oftentimes these actions are citing government health advisories as evidence of risk and harm. This could all change, of course, with new federal drinking water standards to enforce. Businesses are facing a new wave of lawsuits alleging misleading consumers by promoting their products as quote unquote sustainable or quote unquote natural, despite containing PFAS. Some of those cases we're seeing, like for instance, with McDonald's, Burger King, recreational equipment. But of course, these consumer class actions and consumer cases are typically going to turn on what the actual and individual specific representations and facts are in each of those cases. Moving on from regulation and litigation to a key topic for many of those interested in this webinar, the effect of PFAS on corporate transactions. I'm going to divide this complicated topic into three major categories here: due diligence, the actual transaction document negotiations, and then any post-closing issues to consider. Because PFAS are not designated as hazardous substances under CERCLA yet, they're not included under the scope of the ASTM standard practice for environmental site assessment process, also known as the ASTM standard. So PFAS would be considered a non-scope consideration. Sometimes you'll see them called emerging contaminants. But given the likely CERCLA regulation in the near future, as well as all the litigation going on, typically it's advisable to evaluate PFAS-related environmental impacts as part of an acquisition when appropriate. I'll get back to that issue of when appropriate here as we go on. But adding an out-of-scope PFAS investigation can be done when you talk with your attorney who helps you facilitate with an environmental consultant or directly with that environmental consultant. You can have it included in the phase one as a separate section of the phase one report as a kind of a non-scope item. You often see these, for instance, in current reports related to asbestos or lead paint. You could also ask for the consultant to prepare a PFAS investigation as part of a separate report. The environmental professionals in those phase ones or separate PFAS investigations are going to consider current and historical usages at the target site, as well as adjoining and nearby properties. Now, because it's not regulated under CERCLA, PFAS issues are not going to qualify as a traditional recognized environmental condition or REC. Typically in a phase one, you'll see them classified as an environmental business risk. These risks can have material environmentally driven impact on the business, but please keep in mind, depending on the state of your transaction, there's going to be some other statutory requirements, maybe more regulated to the point of wanting to extend your scope of your phase one, especially, with regard to Connecticut's property transfer program, New Jersey's ISTRA, Michigan's baseline environmental assessment program. Phase two investigations discussed here, I'm going to get back to here in a second. But before we get to the actual specific diligence questions a buyer will want to ask a seller in a transaction, you're going to need to take a general interrogation and assessment of whether PFAS is part of the transaction. This is basically decide if further PFAS investigation is appropriate. So you're going to assess these factors. And as you're going to see, it often depends on the type of target company, the current law, and the state where the property is. So you're going to assess the target company, whether there is any likely current or historical usage, manufacture, sale, handling, or discharge in any way of PFAS. So you're going to look at the type of manufacturing, if that's implicated. You're going to look at other industries that could have some PFAS adjacent type processing. You're going to look at sites where AFFF may have been used, former military bases, airports, fire stations. You're going to look at sites that may be downstream or near from wastewater treatment plant discharges, or former junkyards or landfills. Next, we're getting into the specific due diligence requests that may be either in a corporate transaction's initial due diligence request list, or you might need to put them in supplemental, depending on the level of assessment at the beginning of the transaction. At the very least, if your phase one site visit or the user questionnaires have hints of PFAS being in play, then there will need to be specific preparation of supplemental requests with targeted questions. These can help narrow or expand what you're looking at. For instance, how were these PFAS compounds used? In what form and in what processes? What, if any, contaminant control and or management procedures are in place? What does the company do with its PFAS waste? Have there been any spills or discharges or releases of PFAS? What was the mechanism of release to the environment? Air, discharge to surface or groundwater, dumping, discharge to POTW, which is often common. Does the facility use AFFF, or has there ever been a fire requiring the use of AFFF? Because PFAS is that non-scope item under ASTM standard for CERCLA, most cases in your phase one, it will not designate PFAS as a REC, whether based on current or historical usages, neighboring properties. So like I said, it's going to be an EBR, an environmental business risk. So because of this, oftentimes you're going to find yourself in a gray area as to what to do next if PFAS comes into play as a result of the phase one. The questions will be whether there will be a recommendation of further testing or investigation by the environmental consultant. Will there be a recommendation of phase two testing or a limited site investigation? Let's remember back to that slide where I talked about some concerns about a phase two when we're talking about PFAS implications. What are some things we need to consider? whether the landlord will even permit access to a buyer to test for PFAS, whether there are reporting obligations, as we discussed before. Individual states have reporting obligations at different levels, depending on the state, which you need to pay attention to in your transaction. There's oftentimes attorney-client privilege or confidentiality concerns. So talk with your attorney. You got to consider whether you're a buyer or seller in the particular scenario. Consider these reporting, consider these reporting requirements and state cleanup standards. Also important is whether the contamination is believed by the environmental consultant to be on-site or off-site. Other considerations, before the EPA, the environmental professional drafts and finalizes the report, whether there are any recommendations as for phase 2 sampling or testing, oftentimes the client or the attorney should have those informal conversations before anything is finalized. Next, I want to get to negotiating the transaction documents. Key parts for your attention: the definition section and in the purchase agreement, reps and warranties, specific indemnities and releases, and then outside of the documents themselves when insurance comes into play. Consider the definitions of which PFAS compounds are included. Are they going to be defined as hazardous materials or hazardous substances? The definition of environmental law, pay close attention as to whether future federal or state regulations are included therein. Reps and warranties. Again, pay attention to the definitional section for hazardous materials and substances. You're going to need to consider knowledge qualifiers, whether any known contamination by PFAS needs to be scheduled. Of course, to the extent there is known contamination in any scheduling of such, that will have an impact on rep and warranty insurance coverage, but it's more of an open issue if there's no known contamination and losses are incurred from exposure to or even the existence of PFAS. Insurance, currently there's no standard industry exclusion, but is it coming? You need to speak with a knowledgeable broker when it comes to PFAS coverage under environmental insurance. The insurance industry is monitoring this, so it's getting harder and harder to get that coverage with regard to PFAS. And then also include in your examination of the transaction documents any specific indemnities and releases. This is a common practice of buyers and sellers to agree on disclaimers of extra contractual representations, limit any recourse to an express indemnity, and further limit that indemnity through survival periods or monetary caps. In the case of a non-recourse transaction with rep and warranty insurance, these limits are typically even more protective of a seller, providing only that the seller's representations don't survive closing, in the exception of fraud, and the buyer will have no recourse. So sophisticated sellers may seek to obtain a broad release from the buyer as to any and all claims, losses, damages arising out of or relating to the property that the buyer is acquiring, except as expressly provided for in the indemnity in the purchase agreement. Post-closing, there may be also some considerations depending on the deal. Covenants could come into play. Are there activity and use restrictions or limitations based on the presence of PFAS? Are they limited to specific contaminants? Are they limited to specific areas of the property or specific media? Other considerations, the funding of the cleanup. Is there going to be an escrow portion of the purchase price set aside for PFAS cleanup? What is that number? How do you get to that number? What is a trigger for the escrow release? Is environmental insurance at play? Control of the process post-closing. Is there a meaningful opportunity and ability to participate in communications with the regulating agency and comment on draft reports? What are the cleanup standards? And state-by-state voluntary cleanup programs. Are there notification requirements? So keep that in mind. And with that, I will now finish up my presentation. I'll allow some time for questions and turn it back over to Chris Jones.
So that was a lot of information. As you can tell, there is a lot going on at both the federal and state level. We did get some questions during the presentation. The slides will be available, and I believe the recording will be available as well if you'd like those. I think they're going to be sent to you. The challenges of trying to put this all together is so much of it is important on all different levels that's why there is so much information in this presentation. There's also a tremendous amount of uncertainty, which is where the last part of Chris Ward's presentation comes into play, and that is the deal documents, trying to account for some of these unknowns going forward in a deal. We have run into some deals where it was a problem trying to get insurance. We've run into litigation situations where even though the facility has never used any of the PFAS substances in their process, their incoming water from their water system was contaminated before it got there. Recall Sarah's slide of where PFAS is, which is it's everywhere. And so the challenges of trying to determine what you may or may not be liable for are really important to deals and to moving forward with particularly manufacturing facilities. The other part of this, and I probably want to put some emphasis on it, is if these substances are determined to be hazardous substances under CERCLA, it really opens up a whole lot of other issues because of the strict joint and several liability provisions of the CERCLA statute, Superfund. Sites that people may have thought have already been cleaned and taken care of may run into these PFAS issues. So we tried to put as much as we could in, and appreciate all your attention. Appreciate the questions you've had. Our contact information is on the screen. So if you, I'll give everybody a minute. If you have a question you want to put into the Q&A, we can hang on for a minute. But thanks again for paying attention to our presentation. I see one in the Q&A. Has there been recent news and or regulatory activity related to PTFE, Teflon, given its frequent usage across consumer and medical products? Chris, do you want to talk about that in terms of consumer issues?
I would say that in terms of Teflon and especially with regard to cookware, I believe that there are at least 6 states that have specifically targeted cookware in their state regulations. So when we're talking about those regulations, there's going to be either a ban or a proposed ban of use of PFAS as an ingredient in anything that could be used by consumers and allow for that PFAS transfer. So that is something that I can note with regard to your question. And since we had so many different products in so many different states, I didn't have a slide that listed those states, but I can follow up and provide a copy of those states which are specifically targeting those kind of constituents which contain PFAS related to cookware.
Well, we got a thank you from Rakesh Kapoor. So thank you for your appreciation of the presentation. There was quite a bit of information involved. So we appreciate everybody sort of getting through how thick that was to pay attention to it. So thank you. And with that, I think we are ready to sign off. So thanks again to everybody for joining us. I hope you have a great rest of your week, and thanks for listening to our presentation.